Hi Lorraine,
Hi.
Back in the studio for our little podcast. This time we want to look at a constitutional topic. We've looked at a couple of international law topics in the past, but this time we want to look at the constitutional topic, and the one that's burning literally is, for lack of a better word, the Section 44 problem that has taken up Canberra and is very timely and current.
Absolutely, and as we speak, Parliament is considering today motions that are going to be put forward to refer Senator Malcolm Roberts to the High Court potentially in relation to the question of dual citizenship, to potentially conduct an audit into all members and senators to determine whether they meet the requirements of the Constitution. And of course, yesterday, the Parliament referred former Senators Scott Ludlam and Larissa Waters and current Senator Matt Canavan to the High Court to have their eligibility determined. So it's an issue that is going to the High Court and is certainly occupying a lot of Parliament's attention at the moment.
And it is indeed amazing because it is a historical first that one particular parliament is vexed by these issues in such great numbers with political impact, potential political impact.
Oh, huge political impact. And if you look at Section 44 more broadly, of course, Section 44 isn't just dealing with dual citizenship, it deals with a range of disqualifications, and a number of them have been in play in this particular parliament and certainly have a real impact in terms of what the High Court's going to say in the next few weeks and months about whether the government itself actually survives.
All right, then let's get into it and look at some of these issues. And I guess maybe a good one to start with would be the citizenship issue, which is one of these issues, but only one, amazingly, where we've had a couple of problems arising under Section 44 with existing or presumably existing citizenships of foreign countries. What's going on there in that context?
Well, so Section 44, subsection 1 is, of course, the dual citizenship requirement, or what's been interpreted as the dual citizenship requirement. But if you actually read the section, and, pulling out my pocket constitution that I carry everywhere with me just for constitutional discussions like this, Section 44.1 refers to disqualifying any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or a citizen or entitled to the rights or privileges of a subject or a citizen of a foreign power. And if you fall within the terms of that, you're disqualified from either sitting as a member or senator or being elected in the first place.
So that's fairly sweeping, and if one were to grammatically interpret it, the clause alone, on that grammatical level, one would have to say that just having the citizenship of a foreign country disqualifies a person, full stop. Of course, we already have some guidance by the High Court that may not be the only understanding of this norm in the context of citizenship.
Indeed. And of course, this was an issue that has come up in the High Court previously, and what the High Court has said is that we need to place a reasonableness requirement around this, so that if you're a dual citizen, you're disqualified. But if you've made reasonable efforts or all reasonable attempts to renounce your dual citizenship, that's enough to escape the disqualification.
And I think one driver of that is that the idea that a foreign country which alone governs its citizenship could determine who gets to sit in the Australian parliaments wouldn't make much sense. So there has to be some kind of balance, and it cannot be just the fact alone that you turn out to be a citizen of a foreign country, even if it is not your fault, even if you couldn't have known it, because that would in essence create that power in a foreign power to determine who's in parliament.
Exactly. So if, for example, North Korea turned around tomorrow and decided to make every Australian parliamentarian a citizen of North Korea, would that mean suddenly the whole parliament is disqualified? That's an absurd proposition.
Exactly.
And the High Court used that type of example to say there had to be a level of reasonableness, particularly because we know the law that we're looking at here is the citizenship laws of the foreign nation concerned. Every nation has slightly different requirements in relation to citizenship, and some nations don't allow you to renounce your foreign citizenship. So that would mean, for example, if you were a dual citizen with a country that didn't allow you to renounce, a strict reading of Section 44 would mean you'd never be eligible to sit in the Australian Parliament. But the High Court, of course, have limited that and said reasonable efforts.
And it is you don't need examples such as North Korea. In essence, every country that follows the descendancy principle, which many do, many European countries do, many countries around the world do, it is theoretically conceivable that this can go back many generations and that you can be a citizen of that country because of your grandfather or great-grandfather or whatever having been a citizen. So it is a difficult topic, and there has to be some kind of a reasonable test. The only thing I would say to that with a smile in my cheek is, from a constitutional interpretation perspective, you are going to have to say that there is such a thing as object and purpose of the norm. There is a systematic context in which the norm is situated. There is more than just the mere words, which would, on the face of them, say, oh, you have a citizen out. And obviously, as you correctly pointed out, that could lead to absurd results, and it'll be the High Court's task to sort these out in the cases, the case of the Queensland minister.
But one of the things the High Court has done when it's looked at this provision before is to look back at the convention debates, at the discussion at the time, to see what was actually intended by this provision. And what they said was, it's in place for important reasons. It's there to ensure that there is an undivided loyalty, that anybody who's representing the people in the Parliament is loyal to Australia and no other nation. And so in looking at that, the High Court have said, well, if you've made all reasonable efforts to renounce a foreign citizenship, that question of loyalty isn't really an issue. And they also looked back and said, well, at the time that this section of the Constitution was introduced, what were the circumstances? And it's interesting, it's only really become an issue more recently, but there are good reasons for that. At the time that the Constitution was introduced, nobody was an Australian citizen. There was no such thing in terms of the legal concept, and that legal identity only really came about in the 1940s. So everyone was a British subject. Everybody had a foreign allegiance back when the Constitution was first formed. And indeed, up until 2002, Australia didn't actually recognise dual citizenship in a legal way. Although there were estimated to be around 5 to 6 million dual citizens, it wasn't something that you could assume voluntarily. So when you became an Australian citizen, you automatically renounced your dual citizenship at that point in time. That's all changed, and that's why Section 44 is becoming more and more of an issue, because dual citizenship is something that's becoming more and more common.
Indeed it is. So we'll see how the High Court defines the reasonableness of the undertaking in the cases that have been put before it in its capacity as the
Court of Disputed Returns.
Court of Disputed Returns, Electoral Court, and surely they will be able to maybe specify a little, because the minister from Queensland,
Senator
Canavan, is an interesting case. Because in some ways there is evidence for him that he could have been a foreign citizen. In other ways, it is a bit.
Well, I think it's an interesting case, because if you take his story at face value, so let's assume that what's on the public record is correct. He's become a foreign citizen based on his mother, and he never knew he became a dual citizen. So in that circumstance, the question for the court is really, in a case where you don't know and have no reasonable way of knowing, or no reasonable indicator to suggest that you might be a dual citizen, can you be expected to take reasonable steps to renounce your citizenship? Now, I think in his case, it's really going to turn on what the facts prove, and whether in fact he had a level of knowledge about whether he was a citizen or not. Because, for example, to go one step back in the case of Larissa Waters, again, you can be quite sympathetic to the idea that clearly she moved from Canada when she was incredibly young. She's been in Australia for a very long time. She's never been back to Canada. She didn't seemingly know that she was a dual citizen. And yet in her case, you can say, well, the fact that you were born overseas perhaps should have alerted you to the fact there might be an issue there. And one thing to keep in mind with Section 44 is that these are requirements not to just go and join your local footy club. These are requirements for being a member of Parliament, which is a fairly significant thing.
Indeed it is.
So the requirements are what the requirements are, and the onus is clearly on parliamentarians or people wanting to nominate to make sure that they're eligible before they nominate. And furthermore, the law's never accepted that ignorance of the law is an excuse. So There are lots of interesting
It's
questions
difficult,
swirling around.
and in that particular case, born to parents of another citizenship often means that you are, without signing anything, doing anything, ipso jure, a citizen of that other country. So, in any case, I think the High Court might have opportunity to exploit the concept of reasonableness a little bit further, and that might solve that problem. But there are other issues in Section 44 as well.
Of course. Perhaps before we get to them, though, one of the interesting questions that you raised in relation to the dual citizenship question is the idea of the implied universal franchise. And I think that's just worth quickly flagging, because it'll be interesting to look at how the High Court reconciles what it found in cases like Roach and Roe, where it did find there was an implied universal franchise effectively in Australia, with how it then looks at this dual citizenship requirement, which in effect prevents a significant number of Australian citizens from being eligible to run for Parliament. So reconciling that idea of broad participation from a voting perspective, but much more limited participation from an eligibility to run perspective, it's an interesting constitutional interpretation.
It's an interesting question. My take on that particular question would be that it is not as problematic as another context, because it is something that I control. So it's a subjective limitation, if you will, and whoever wishes to run and stand for Parliament can turn himself or herself eligible by doing whatever is reasonable and renouncing the citizenship if they have reasonable cause to think that they might be a citizen of another country. So I control that. Whereas in other areas of suffrage, it's objective. The criteria are objective, and the person doesn't control them and cannot control them. And then other issues arise, and we might get back to when we look at some of the other 44 issues, whether they play a role in that same, or might play a role in that same context as well.
Yeah, and I think that question of reasonableness does come through when you look also at some of the other issues that are going to come before the High Court in terms of Section 44. So Section 44 subsection 1 deals with dual citizenship. Section 44 subsection 2 deals with treason and criminal convictions, and so you're disqualified in relation to certain criminal convictions that you may have. Subsection 3 is bankruptcy and insolvency. Subsection 4 is if you have an office of profit under the Crown. And subsection 5 is direct or indirect pecuniary interest disqualifies you. So there's a range of measures, and interestingly enough, nearly all of them have come up in the term of this
so
most
let's look at
recent
the second
Parliament.
one, which is the treason and criminal conviction.
So that was considered in conjunction with the bankruptcy provision in relation to the case of former Senator Rod Cullerton. Well, actually, according to the Court of Disputed Returns, somebody who was never a senator because he was never qualified in the first place. And he was actually disqualified because he had a criminal conviction, and at the time of nominating was convicted and yet to be sentenced for an offence that carried a potential term of imprisonment of 1 year or more. So he was convicted of larceny in New South Wales. That conviction has subsequently been, well, the original conviction was subsequently overturned, and then he was convicted again. But he was disqualified at the time of nomination because of that Section 44 provision.
And this is irrespective of the fact that the actual sentence that came out of it was less than 1 year imprisonment.
Absolutely.
So
it was
just a potential of having this type of crime carries the potential of having a year or more.
That's right.
It's not the concrete circumstance; it's the general circumstance of the criminal provision in question.
And you're not disqualified forevermore. You're disqualified at the time when you're convicted and awaiting sentencing, or while you're under sentence. Once you've served your sentence, you're free to run for Parliament again. But the interesting thing about that particular section is the terms are incredibly clear. There's no real argument about what the disqualification is. It's the factual application that has people questioning whether, in fact, we do think that somebody who has been convicted of stealing a tow truck key that's valued at $7 should be precluded from running from Parliament, or indeed whether simply by disclosing that, the people themselves can make a judgment call.
Indeed, that seems odd, that such minor things, just because they are technically wrapped up in a provision that covers much more serious things as well, falls like in the ambit. Because you could easily imagine, from the way you write the criminal code, that you have, the easy larceny, the lower level larceny in a separate provision, and say, punishable by fine or imprisonment up to 6 months. And then you have, in a separate provision, you have the more serious cases, a year or more, or whatever, in which case the same crime would not carry any consequence. But if you put it into one provision, then all of a sudden it does create that severe consequence. Quite interesting.
But what's also interesting about that is the High Court have said the determinative time for disqualification is actually the time of nominating, not the time of the election, not the time at which you take your seat, but the time of nominating. And in the case of subsection 2, when you're dealing with criminal convictions, it may be that on the day you submitted the paperwork you were technically ineligible, but from the very next day you were eligible again to be in Parliament. So it really does come down to a question of timing. And whether a question of timing like that should have such a significant impact in terms of stopping somebody from being able to sit in the federal parliament.
And Section 44 is quiet on that, on the timing. It covers only, in essence, could be construed to cover only the exercise of office.
Well, and the High Court was split on that issue. The majority in the case that considered it did say it was from the time of nomination, but there were judgments that suggested, no, actually we should look at the day the election is declared. So there's an interesting discussion about the timing of all of this.
So maybe that comes up again. We'll see. But there's less time to maneuver in that, especially not in the treason. It's a little less time, a little less space to maneuver in terms of interpretation and what the High Court could do to ease the effect of it in this particular subsection.
Exactly, and I think that's the same when you move to the next subsection of bankruptcy or being insolvent. Again, the law is very clear. If you're an undischarged bankrupt, you're disqualified. And that was something that could have applied in relation to former Senator Cullerton, but at the end of the day it was the criminal conviction that was a significant problem, as well as the bankruptcy, both of them working in tandem. So the bankruptcy issue may come to be tested again. There's some suggestion in relation to substitute candidates if certain candidates are declared ineligible, which is where this whole thing gets so complicated. But the provision itself is very, very clear. Interestingly, once you have been a bankrupt and you're discharged from bankruptcy, you're eligible again. So it's not a permanent disqualification, it's just for that period of time.
So that can be quite harsh. There's administrative problems, I suppose, and when does bankruptcy begin? Because it's always tied to a procedure, the insolvency procedure. But as you say, otherwise it's fairly clear and leaves relatively little wiggle room. And then, of course, we have the next one, which is the Office
of Profit under the Crown,
yeah.
Which is an interesting one from a direct perspective for us as academics, because it looks as though the academic side of this could be tested. With Larissa Waters presumably going to be declared ineligible and the fact that she's resigned, the real essence of the case before the High Court in relation to the Green senators is how their replacements will be chosen. If the High Court declares that she was never eligible to be selected as a senator, which seems likely, her replacement would then be the number 2 ticket holder on the Greens ticket from the Queensland election, which is Andrew Bartlett. Of course, he was a university lecturer at ANU at the time of nomination, so the question is whether he held an office of profit under the Crown and therefore is disqualified under Section 44. That's something that's never really been tested before, and it seems likely that there may well be a challenge to his eligibility following on from the challenge to Larissa Waters.
So if one construed this criterion relatively broadly, and given the fact that universities are public institutions, most of them state, the ANU, in fact, even the federal one.
Exactly.
So even closer, you could, with one such interpretation, really exclude quite a few people from being eligible to stand.
And it's clearly accepted that, for example, school teachers, members of the Defence Force, etc., fall under this provision, and there are well-established rules in Australia at a public service level, for example, about how people can resign before they nominate, but then they're guaranteed to get their job back after the election, etc. But in the case of, for example, local councillors, it's not clear whether this provision extends to them in the case of academics. And it really does open up a whole can of worms, because the very thing we want in Parliament is to have a broadly representative.
I looked up the numbers in the German Parliament, and roughly a third of the 630 members of Parliament in the what you would call the House of Representatives would be ineligible if these rules applied, because they are civil servants or public employees, teachers, judges, university members, professors, and service people. Now, they will, the way it's handled there is while they are in Parliament, they cannot continue to work. So, their job rests, and then they go back afterwards. But the fundamental difference is that everything starts only at the beginning of the office and not at any nomination period. So then they have to step down from their other office, and that, is just placed in the cupboard for the time being. And then if they stop being a member of Parliament, then they go back to their original position, become a teacher again, or whatever the case may have been. But I find this interesting. Roughly a third. Would be ineligible, right?
And the fascinating thing about it is you can understand the reasons behind the Section 44 provisions, because you don't want to have people that have that direct conflict between being in Parliament but also holding an office under the Crown. That's clearly inappropriate. But you do need to find a balance between then providing people, for example, who are local councils, or not that we need more academics in Parliament probably, but people who are academics or people who are teachers or in the Defence Force. You want to give them an avenue to engage.
Indeed, yeah, that's very important. So, of course, some way for the High Court to potentially limit the scope of that clause by way of interpretation. Is that one linked already to the profits derived?
Well, it's a separate clause, but there is obviously that linkage. And I think the way the High Court can address it is by providing clarity. Because again, as you said, this is subjective. If people know what the rules are, they can take steps to make themselves eligible if they want. And that's similar with the direct or indirect pecuniary interest, which is the final clause. Now, obviously, if you have a direct pecuniary interest through having a direct contract with the government, that would just straight away exclude you. The really interesting part is the indirect pecuniary interest, and that came up most recently with former Senator Bob Day, and the High Court ruled that he was ineligible to be a senator because he had an indirect pecuniary interest through the renting of an office block that he had an interest in at one point, and there was quite a complicated arrangement in place, and that office block actually housed his electorate office, so clearly there was a Commonwealth payment of rent in relation to that. But what the High Court said is an indirect pecuniary interest really relates to a conflict of interest. So it's important for parliamentarians to place their duty to the Parliament above any personal interest, and that's what this section is really looking at. Prior to the Bob Day case, this has only been considered once before. It was decided by a single judge. A very narrow approach was taken to what an indirect pecuniary interest might be. And so when the High Court reconsidered it in the Day case, they took a much broader approach and really placed at the centre of it this idea of a conflict of interest. It's now obviously coming to light again and will be reconsidered in the David Gillespie case. He's a National Party Member of Parliament who's been referred through to the High Court in terms of whether he had an indirect pecuniary interest at the time of the last election on the basis of a shopping centre that he has an interest in, which rents a space to a lady or a business who are connected to the Australia Post service. So they're a franchisee of Australia Post. The idea being Australia Post is a government agency. They obviously therefore have an interest in the particular centre, and therefore there's an indirect pecuniary interest.
That is when matters are taken to the absurd level. But look, it is in the language of the indirect of the provision, but it is almost then becomes unavoidable to run into such conflicts, which are not really, where you could hardly say a conflict of interest.
It's not getting to the heart of what this section is designed for. On a strict literal interpretation, clearly there is something there, but again, you would hope that the High Court would look at placing the idea of conflict at the centre of this and really putting some reasonable parameters around it to make sure that we're not getting to a point where we're going 20 steps down the line to find an indirect interest, because it does just get to nonsensical proportions.
Yeah, you know, given that if you compare that to other potential conflicts of interest, you know, any superannuation legislation that goes through Parliament will, of course, affect in numerous ways every member of Parliament, whether it's through their own superannuation account, whether it's through superannuation accounts in their family. It's unavoidable that you are somehow, indirectly affected by the legislation that they pass. It's just unavoidable. So to in this particular instance, to construe it into the absurd, would make no sense. It would be, but hedging. It has to be hedged, and that's what constitutional interpretation is for. That's what the High Court, why we have the High Court.
But the particular significance of that case, of course, is the member being referred is a member of the House of Representatives, not a senator. And given that the government holds office with a one-seat majority in the House, this is the case that is truly politically significant versus the other cases, which are obviously important, but concerning the makeup of the Senate. So it's not going to have the same impact in terms of potentially changing the government of the day.
Unless he was in a district where the by-election is a safe.
Well, it's a safe national seat, but it's a seat that he won off an independent. So there's a potential in this current environment for anything to happen.
Indeed. So we will stop this now because we've gone a bit over time, but we will come back to it when the High Court has given its decisions, which I understand will not take overly long in this, because they have to make these pronouncements, right?
Well, they're aware of the significance of the matter, so you'd expect the High Court to move as quickly as it could in these circumstances, whilst of course giving proper consideration.
Of course, but that means it is, it won't be late next year. By the time they decide this, it'll probably might even be this year, or am I too optimistic there?
Well, you would consider, given the timing from the Cullerton and the Day matters, that all happened relatively quickly, so you'd expect to see.
So then, with the guidance given by the High Court, we can then come back and discuss whether the guidance was okay or whether we need to refine it.
And who knows, with the current Parliament, we could have more members coming before the High Court between now and then. So.
Okay. Well, thanks, Lorraine. Always interesting. Constitutional matters. And until next time.
Absolutely.
Cheers.